So the Supreme Court just heard arguments in two landmark cases which are huge for the Second Amendment movement going forward. So let's talk about what just happened in the Supreme Court. But real quick before we jump into this video, I want to ask you guys for a huge favor. The channel right now is just sitting below 600,000 subscribers. I was looking at some of my analytics, and about 60% of all my viewers across the channel are actually not subscribed to the channel. So if you've been watching this channel for a long time, if you enjoy these videos, please consider subscribing to the channel. It will help to not only grow the channel, but it signals to the algorithm that it should push this type of content out to more people so that we can inform more people about the 2A movement and things that are going on that affect our right to keep and bear arms. As I mentioned in the intro, in this video, we're going to be discussing two important cases which the Supreme Court just heard oral arguments on this week. The oral arguments which took place, in my opinion, were historic and probably have broad implications for what will happen not just in the legal world going forward, but also this will drastically impact a lot of practical aspects in the nation, including our right to keep and bear arms and how agencies are infringing on the Second Amendment. The cases we're going to be discussing and the arguments took place in the Loper Bright Enterprises v. Raimondo case and then also the Relentless Inc. case. These cases aim to use issues over phishing to bring an end to Chevron deference once and for all. In this case and other cases, government agencies like the ATF and other agencies like those involved in this case claim that whenever a statute is silent on a topic or even ambiguous, that means that Congress has delegated powers to that agency and they can take regulatory actions as they see necessary. And the oral arguments that just took place in front of the Supreme Court, I think bode really well for an elimination of Chevron deference forever. Chevron deference is a term coined after a Supreme Court case called Chevron versus the NRDC, which was decided back in 1984. This case established the concept of courts giving deference to an agency's interpretation of claimed ambiguous statutes or terms that Congress has tasked that agency with implementing. However, generally for an agency to be given Chevron deference, the agency's interpretation of an ambiguous statute or term must be found rational or reasonable by a court that is reviewing that action. Under the doctrine of Chevron, it is pretty much just allowing Congress to delegate their lawmaking powers to an executive agency, and also it then takes the judicial power, the legal review power away from the courts, and essentially says not only is the ATF able to legislate, but then they're also given broad deference by any court that is reviewing their actions. It essentially just makes them judge, jury, and executioner all in one, and again, this comes from one Supreme Court case. Now, in contrast to Chevron deference, there are other canons of construction that courts sometimes use when they review statutes. They can use things like the rule of lenity, and essentially that means that when they're using the rule of lenity to interpret a statute that has criminal statutory interpretation risks, when it has criminal statutory implications attached to it, what that doctrine says is that a court on review is required to apply any unclear or ambiguous statute in a way that is most favorable to the people, not the enforcement agency. There's also some other concepts like the major question doctrine, which the Supreme Court used recently, I believe last year in the West Virginia v. EPA case, and then also recently in the student loan decisions. Now, since essentially 2016, the U.S. Supreme Court has moved away from using Chevron deference and just exclusively relying on it. In fact, they've issued multiple decisions like I've just referenced, which are attempts to rein in Chevron deference. But ultimately, there is still a lot of lower courts and a lot of judges who almost every single day are using, the doctrine of Chevron to uphold agency actions. But all this has now come to a head. There are two cases which the Supreme Court just heard, and essentially Chevron deference is on the chopping block. Now, I want to break down some of the main takeaways and some of the few things that I found very interesting during the oral arguments. I will also link both of the arguments down below if you want to listen to them for yourself because it's very interesting. Now, first and foremost, the thing that always happens during these cases, especially when liberal justices like Kagan, Jackson, Sotomayor are not happy with what is happening, they express a lot of concerns, and one of the main concerns that those liberal justices put forward was the fact that an agency is an expert in an area and therefore should be the ones to interpret statutes and essentially fill any gaps, and it shouldn't be left to the courts. A lot of times they were expressing concerns about how the courts would just simply be flooded. It's going to leave a lot of policy making to the courts, and so they were expressing a lot of concerns about how the courts will just be doing policy, which they're not supposed to, how the courts will be flooded. If Chevron is done away with, then those 70 cases have to be relitigated. So they're expressing a lot of concerns about what would happen if Chevron deference is done away with, which is also a very clear signal, especially if they're that, adamant and pushing back and we're getting very fanatical during the arguments. It probably signals to you what is exactly going to happen, which means that Chevron at the very least is going to be restrained significantly. But in my mind, I think they're just going to do away with it altogether. The liberal justices put forward positions in the arguments that oftentimes justices are not the ones who are most knowledgeable on certain topics, that they don't have the technical know-how when some of these issues come up, in front of them. And then it was also interesting because they were talking about how it takes humility from justices and judges to admit when they don't know something, and instead they should defer to the experts, which are the agencies. Now, again, funny about that because a lot of times the experts in these agencies, are not experts at all. Look at just what happened with, Dettelbach, the director of the ATF, when he was in front of Congress. He couldn't define certain things. He even claimed himself he wasn't an expert on firearms, and yet he is the director of the ATF. And those are the quote unquote experts who these liberal justices say that the court should defer to. But the government argued that many people have also relied on the court's guidance on Chevron, and therefore it would be improper to do away with it because a lot of people have relied on Chevron, and a lot of people have relied on what the agency has said as far as various guidance on some of these topics. Now, again, there was a response by the petitioner's attorneys, but there was also a lot of statements from Justice Gorsuch and Kavanaugh in some of their questioning. And Kavanaugh and Gorsuch first pointed out that the Supreme Court has already been kind of reining in Chevron over the past few years. So that's already kind of signaled to a lot of courts what they intend to do. So, a lot of courts probably aren't really relying on Chevron anymore. And I think there has been a little bit of a dip in some of the statistics about, decisions which are relying heavily on Chevron. But more importantly, that reliance on agency interpretations kind of cuts both ways, and the justices here, Gorsuch and Kavanaugh, point that out. In fact, it's the agencies that engage in flip-flopping all the time. Their interpretations change almost every single, 4 years when a new president and regime comes in. And again, that especially in the two-way community because the ATF has engaged in multiple times flip-flopping in their positions. They've changed their position on bump stocks, pistol braces, suppressors, unfinished frames and receivers. It happens all the time. If anything, it's Chevron deference that actually allows agencies themselves to create chaos and a lot of confusion. Then there was a lot of back and forth about silence and gaps in the statutes. And I think a lot of listeners actually missed out on these arguments. I haven't seen it discussed a whole lot. The government tried to argue to the Supreme Court that an ambiguity, a gap, or potential silence in a statute gives an agency the power to regulate as they see reasonable. But many of the justices actually push back against that concept. Think of it like the ATF saying, well, since the NFA and GCA don't say anything about 3D printers, that means that Congress gave us the express power to regulate 3D printers however we want. But silence and gaps shouldn't be a blank check for agencies to do whatever they want and for them just to be deferred to. But unfortunately, that is what Chevron has created. Now, the last thing I also want to point out and focus on was the fact that at one point, the government representative, the Solicitor General, actually proved why Chevron is not needed and how statutory review and using the canons of construction can actually resolve all of these issues. We do not need Chevron. At the beginning of her argument, the attorney there walked through the various sections of the statute, which she then used to support her position and the government's position that the regulation that's in question is in fact permitted by the statute. And Gorsuch responded by saying, well, that sounds very much and very clearly like an example of statutory interpretation that courts do almost every single day. Why don't we just do that in this case and other cases and not use Chevron? It's only with Chevron and when an agency is involved that the court then all of a sudden says, well, each side reads this statute differently. Well, let's just then look at what the agency says and defer to their interpretation. In all other cases dealing with statutory review, a court can come to a conclusion using just other canons of construction. It's only in agency cases like this one and other cases where courts claim that they can't do that. Gorsuch points out that there is ambiguity also about what even ambiguity even means when it comes to the doctrine of Chevron, which shows just how problematic this methodology is when it comes to this doctrine, and that is why Chevron needs to be done away with. But my main impression from the arguments is that I think Chevron is pretty much done for. I think it's going to be at least a 5-4 ruling doing away with Chevron altogether. I think Alito, Thomas, Gorsuch, and Kavanaugh are very much on board for getting rid of Chevron. I think Justice Barrett, if you listen to some of her questions, I think she reveals that she will most likely rule also against Chevron. Roberts, of course, is always a question mark, but I think also some of his line of questioning shows that at least he's interested in limiting Chevron. So like I said, although this case does not deal directly with two-way issues, it does deal with a major legal principle that has been used time and time again against multiple two-way cases, multiple issues, especially when we are dealing with the ATF. Now we're just going to have to wait for that decision now that the oral arguments have been submitted. Oftentimes these controversial topics, especially something as big as Chevron, will get held until the end of their term. So we'll have to watch, I believe, for the end of their term, which is around end of June, early July, depending on how they kind of pace out their decisions in releasing those. So we're going to be waiting to see that. If I get any more information, if anything else develops, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.